Welcome everyone to this Taylor Wessing webinar on managing design protection in Europe. During the next 45 to 50 minutes we will present to you an overview of design protection in Europe. We will discuss what the requirements of protection are, how to go about clearance, how to build awareness with your design team, writing and dealing with cease and desist letters, and other things. The international Taylor Wessing team presenting today consists of Wiebke Baers from Germany, Martin Prohaska from Austria, Tom Carl from the UK, and myself, Maarten Rijks from the Netherlands. We will discuss design protection on a European level, but we will also address some local particularities. If you have any questions during this webinar, please feel free to ask them and we will try to answer them during this webinar, or otherwise we will get in contact with you afterwards.
First of all, it is important to understand what can actually be design. In general, a design right can cover the appearance of the whole or part of the product shown as a picture, 3D drawing, drawing of lines, contours and so on. Tom Carl will discuss the coverage later on. In order to rely on the protection of design rights, the Community Design Regulation and the directive require your design to be novel and to have an individual character. A design is novel or new if no prior identical design has been disclosed before the filing date of the design application. And identical in this sense means that the features of two designs only differ in immaterial details. Disclosing means making design available to the public in such a way that the interested circles specialized in a particular sector and operating within the EU could reasonably be aware of the design. And in this regard, using NDAs is highly recommendable if you work with third parties in the design process. An important exception is the so-called grace period of 12 months preceding the filing date of your design. The grace period allows the designer to disclose its design to the public and to register its design still validly at a later stage, as long as the application is made no longer than 12 months after the first publication of the design. Secondly, a design has to have individual character in order to be valid. A design has individual character if the overall impression it produces on the informed user differs from the overall impression produced on the informed user by already existing designs. And when assessing if a design has individual character, the freedom of the designer has to be taken into consideration. It is also important to know that design cannot consist of features which are solely dictated by its technical function, or when it's dictated by dimensions necessary to interconnect with another product. The question is, of course, when a design is solely dictated by its technical function. And this question has been answered differently across Europe over the last years. Some countries interpreted this exclusion by ruling that if a technical alternative was available, the design could not solely consist of its technical function. Other countries and the EU IPO, however, interpreted this exclusion by ruling that if there were no aesthetical considerations that contributed to the design was solely dictated by its technical function. And in the very recent Doserem case, the European Court of Justice ruled on the 8th of March 2018 that the technical exclusion ground applies if the technical function was the only factor contributing to the design. The European Court of Justice therefore clarified this exclusion and decided in favor of the so-called no aesthetic consideration test, as was already applied by the EU IPO before. The fact that there are technical alternatives therefore cannot be an argument anymore. I will now pass on to Tom Carl.
Thank you, Martin. So I'm going to go through a quick overview of the four possible types of registered or unregistered protection that you might look at for protecting your designs in the EU. And we'll see that there's different degrees of pan-EU protection and also different degrees of national harmonization across the 28 member states. So looking at the first possible type of protection, registered designs. So here we have a pan-EU registered design in the UK called the RCD, or the Registered Community Design. And we also have harmonization for national registered designs across the 28 EU member states. And as Martin mentioned, so those broadly cover the appearance of the whole or part of a product. More specifically, it can cover anything from the lines, contours, colors, shape, texture, or even materials of your designs, and also their ornamentation. So really you can look at protecting products themselves, packaging, get-up, graphic symbols, and also typefaces. As Martin mentioned, technical features are generally excluded. In terms of duration, you're looking at a right that's renewable every 5 years for up to 25 years. as Martin mentioned, there's the 12-month grace period option, but do remember that some countries like China don't have a grace period, so it's important to keep that in mind as part of your overall strategy before disclosing your designs. There's also a possibility of deferring the publication of your registration for up to 30 months if you want to keep it secret over that period. And you can also take advantage of the 6-month priority claim system. In terms of ownership, the rule is that the designer or its employer owns the design. So if you're commissioning a design, it's very important to secure an assignment to make sure that you end up with all the relevant rights. And registered designs are a true monopoly right, so you can claim infringement even if the defendant hasn't actually copied you. Another thing to mention is the Hague Agreement, which allows you to file a single application designating various territories at WIPO rather than through the individual national offices. And it currently covers not only an EU RCD, but also most national registered designs. The UK joined recently on the 13th of June, and I've listed on the slide those EU countries which aren't currently covered nationally. It allows you to submit a single set of images. You can also submit multiple applications in one go, so it can be a very time and cost-effective way of covering several territories. But do bear in mind that you need to conform with the requirements of each designated country that you select, which can lead to issues, in particular in places like the US, Japan, and Korea, which need to be considered as part of your overall strategy. And you'll see on the slide I've given an example of a EU RCD for the famous Trunky suitcase, which we will mention again a bit later. Now moving on to unregistered design rights. So there again, there is a pan-EU form of protection known as the UCD, or Unregistered Community Design Right. The coverage is the same as the registered design right. Duration is much shorter though. It's only 3 years from public disclosure. Ownership rules are the same. There is an added possible issue in that there is a question mark, which currently hasn't yet been decided at a Court of Justice level, as to whether the design has to have been disclosed within the EU as its first marketplace in order for the rights to arise. And there is a German decision which suggests that that is a requirement. It's not a full monopoly right in that you must show that the defendant actually copied your design. And this is an area which has not been harmonized across the EU, and in fact, unregistered design rights are generally not protected nationally. One exception is in the UK, where we have the UK unregistered design right, and that covers the shape or configuration of the whole or part of the internal or external aspects of an article. Importantly, it does not cover surface decoration, and there are also exclusions known as the must-fit, must-match features, which are generally aimed at excluding spare parts. In terms of duration, it's between 10 to 15 years, depending on whether the design was first marketed within its first 5 years, and defendants can seek a license of right in the last 5 years of its term. Same rules on ownership, but an added potential issue with designs originating from the US or Japan, for instance, which may not be entitled to UK designer protection because of the lack of reciprocal agreements in that area. And again, you must show copying. And on the slide here is an example of a UK unregistered design case involving a wedding dress, which was featured in the reality show Big Fat Gypsy Wedding. Moving on to the third possible right, which is copyright. So there again, it's not a pan-EU right. There has been some partial harmonization across the 28 member states. Taking the UK as an example, it's a fairly restrictive coverage in that it must fall within the closed list of types of works covered by UK copyright. So essentially it needs to be a graphic work, a sculpture, or a work of artistic craftsmanship. And that also applies if you're trying to rely on the actual design drawings for copyright infringement. You have to show that those drawings were for the purposes of an artistic work falling within those categories. Duration is generally life of the designer, plus 70 years. Until recently, for certain works of artistic craftsmanship like design or furniture, that was limited to 25 years if more than 50 articles were made to the design. But that law changed in 2016 with a transitional period ending in 2017, so that those types of designs now do get the full life of the designer plus 70 years protection. Same rules on ownership. You must show copying, and here on the slide is an example from one of the most famous UK cases on this issue, where the furniture that you see was held not to be a work of artistic craftsmanship and therefore not protected by copyright. Another famous example in the UK being the stormtrooper helmets, which were held not to be sculptures for copyright purposes. Moving on to our fourth and final right, unfair competition and passing off. No pan-EU protection for those, no harmonization across the 28 member states. Again, to give a UK example, so this is under the law of passing off, where you need to show that you've established a reputation and goodwill in the design and that there's been a misrepresentation and resulting damage. So there the coverage can be anything from the product, packaging, get-up, graphic symbols, and possibly even technical features. Duration in principle is unlimited, and you might also be able to claim residual rights even if you've ceased use for a number of years. The owner will be the owner of the goodwill or reputation, or possibly licensees. So again, you need to possibly flag up the issue of making sure you have assignment provisions in place. Copying is an aggravating but not a necessarily mandatory factor to prove. And here I've put two examples from the UK of the famous Jif lemon case and the Saucy Fish Co. packaging. And last but not least, we should also obviously mention the possibility of registered trademark protection, but that's a topic of its own which we will not be covering today. And finally, a quick word on everybody's least favorite topic for a Friday, Brexit. So following the triggering of Article 50, the UK is set to leave the EU on the 29th of March 2019. But under the UK withdrawal bill, which was passed earlier this week, and the draft UK-EU withdrawal agreement, EU law is to be retained during the transition period up to the 21st of December 2020. So assuming that does go ahead, in terms of the continued protection of rights arising before the 31st of December 2020, with the EU registered community design right, there will be continued UK protection, although the mechanism for that has yet to be determined. The withdrawal agreement also provides for the possibility of filing 9-month priority claims from December 2020 to claim UK registered design rights. And it's unlikely that pan-EU injunctions will continue to cover the UK after that date. For EU unregistered community design rights, there again, there will be continued UK protection for however much is left of the 3 years. Then in terms of protection of rights arising after the 31st of December 2020, there will no longer be any UK protection in relation to EU registered community designs. Unregistered EU community designs, again, no further protection. And then it will raise the question of what if a design is disclosed in the UK first but not in the EU. And finally, it's been announced at the beginning of the month by the UK IPO that the UK is planning on introducing a new UK unregistered design right, which would be mirroring the EU unregistered community design right. So 3-year protection in parallel with the possibility of a 15-year protection would also cover surface decoration and could raise the issue of US and Japanese designers, for instance, that I mentioned earlier. And we will now move on to clearance.
Thank you very much, Tom. Well, clearance, it's an interesting and slightly challenging topic. Before filing a design application, the applicant should gain information on the existing pool of design creations and perform a search for prior registered designs. As Martin said in the beginning, the search helps to find out if the planned design meets the requirements for protection like novelty and individual character. And obviously, through a search, you can see if there are possibly infringing earlier rights that might be infringed. So how can you do such a research? You can obviously get the help of a research institute, or you can use the tools that are available to you as an applicant. Most research institutes undertake searches for identical designs and as well as complex similarity searches, and they offer access to unofficial or sometimes fee-based design databases. What I definitely recommend is before you order a search, get information on costs, as this may be quite a complex process. The costs for such a search normally don't come cheap, but it might still be cheaper than going for, facing an infringement. So I'm trying to move the slide. Yeah, so I've got a blank screen now, unfortunately. Can anybody help me? Well, I will continue talking to you. Before, what you have to know for the search is that design protection is not limited to the chosen classes. Registered designs are fully protected, and the Locarno classification allows to organize registered designs to make them easier to search. So this is a good thing because you've got very broad protection, but the difficult thing is that it's hard to determine the relevant classes for a search. So, for example, we had a case here in Germany where design was was tried to gain for the protection of an oven, and eventually it appeared that this design was not novel because the research showed that there was an identical earlier Christmas decoration. So this certainly would have been difficult to search when looking for ovens. As for tools, you can use Internet search engines, for example, Google Search, Google Image Search. Always have a look at FAIR catalogs if you are searching in your own brand. Product directories, trade platforms on the Internet, for example, Amazon, or registered searches such as DesignView, eSearch Plus, or the Hague Express database. So sometimes for preparing the research, you have to be a bit of a detective. And now I want to discuss the question, which also is very relevant. If you have found something similar, try to determine how litigious the other side is. To assess the risk of potential legal actions of an earlier design holder, you do have a couple of tools available. So one of the best things is to use the database Darts IP, which gives you an overview over owners of designs and also if they have attacked other designs. So if you look for the owner of a previous design in these kind of databases, you might get an overview and see if they're constantly part of litigation or if they tend to be quiet. When should you start the search process? I would say as soon as the design is planned, the applicant should start with the search as described on the slide above, because this ensures that if the search result is negative for the applicant, he or she is the designer that has the time to make changes. So gain time by knowing what your system is. And now I move on to Martin in Vienna, who will talk about awareness and train your designers.
Hello, this is Martin Prohaska from the Vienna Taylor Wessing office. This is just a brief talk on training of designers. So this is another way to manage risk, of course. If you have, let's say, in place a record of independent creation. So if you can convince a claimant that you independently created a product, more often than not, the moral outrage that tends to drive such cases goes away. Thus, you should record who has been designing and when, and very important, keep the briefing records, as well as the sign-offs by the management, of course. Also important is to make the designers aware of the particular risks of iconic designs, and also train your designer on when they should ask for searches and when they should report back on the design process to keep the window, which is often very short for the final design clearance with the legal department. Now, moving on to the next slide on documentation and design process.
Thank you, Martin. In addition to creating awareness within your organization, documenting all steps in the design process is crucial in light of the protection of your designs, but also in light of defending any infringement claims from third parties. Our first step is to communicate by email or in writing, and not only verbally, such as in design meetings or Skype calls. It is important to ensure to document the design process clearly. If necessary, such documentation could be used as evidence in litigation to show which creative choices have been made in the design process. It can also be used in litigation if a third party would raise a claim on the basis of design infringement to show that you did not derive from their design, but actually created your own design. In the process of documenting, it is of course very important to date all design documents. Secondly, documenting the first publication dates and places of your designs is also of crucial interest in light of the novelty requirement. If a design would be published more than 1 year ago, design will not be new and the design right will be vulnerable to cancellation. It is also of importance if you have chosen not to go for a registered design, but to rely on an unregistered community design instead. In such cases, you obviously don't have a registration certificate with a specific date, and your own design records need to prove that you can still rely on the unregistered community design right. Internal reporting is also very important, as Martin already discussed. Such internal reports and sign-offs should preferably be recorded in your files as well. And finally, make sure that you regularly check your design records. This will give you more control over your records and the possibility to intervene if the design records appear not to be complete. Now I will hand over to Tom again, who will discuss C&D letters.
Thank you, Martin. So we're first going to look at the perspective of the claimant sending its own cease and desist letters. And it goes without saying that each case needs to be considered on a case-by-case basis, and sometimes it's going to be better strategically to hold back on certain details or facts. But this is a following outline of the issues that you should consider to present the most comprehensive and persuasive case as you can, and really try and preempt pushback and arguments by defendants as much as possible. So the first obvious thing is to really spell out your rights. So typically that'll involve starting by specifying who the rights holder is and the designer, so giving the designer's name and nationality, and specifying whether the claimant is its employer or a contractor, or whether there's any relevant assignments or licenses in place. Dates play a crucial role in these cases, so you'll want to specify the dates of your designs, as Martin was saying previously. Also the date when the design was first made publicly available, and assuming this is in your favor, going that step further and specifying when it was first publicly available within the EU. In terms of supporting documents, if you're relying on a registered design, you'll want to include a registration certificate. Otherwise, for all cases, you'd be looking to exhibit the relevant design documents, images of the relevant product or packaging, and for reasons that I'll come on to later when we're talking about enforcement, also specifying if your products were marked or web marked. And then obviously if you're also relying on other rights, like passing off, for instance, you'll want to spell those out as well. Now, when it comes to being persuasive, the first element is verbal persuasion. So here you'll want to set out as much detail as possible of what you're saying are the identical and similar features. The other thing really to bear in mind in these cases, though, is that ultimately it is a test of whether the products have the same overall impression. And certainly in the UK, cases have been lost and won on that test. So for instance, in Apple and Samsung, the question was was the Samsung tablet as cool as the Apple one? In the Reckitt-Coleman air freshener case, it was the infringing product reminiscent of a snake's head or another type of creature's head? So assuming that's all in your favor, it's a good idea to try and come up with your own version of what you're saying the overall impression is. In terms of the informed user and design corpus, those are two areas where you might want to hold back in your letter so as not to tie yourself down to specifying what those are at this stage in case it has implications on the scope and relevance of any prior art in particular. Then moving on to visual persuasion, this is really an area where a picture truly can say 1,000 words. So do include side-by-side images, or you can even go a step further, and using CAD or other types of software, you could even create overlapping images of the two designs to show how truly identical or similar they are. And one sometimes common mistake is for registered design infringement cases, the test is between the claimant's registration, not its product as sold, and the defendant's product. So do bear that in mind when describing what you're saying your rights are. Then moving on to thinking about, well, what are you actually trying to achieve on a case-by-case basis. This will depend on the strength of the case and your primary objectives. So on one extreme, you'll be requiring the full remedies to which you're legally entitled, so product withdrawal, disclosure of the manufacturer, supplier, wholesalers, and retailers, delivery up and destruction of infringing products, damages earned account of profits, legal costs, and also publicity. So for instance, requiring the defendant to publish a statement on its website that it was infringing your product, but that those have now been withdrawn. In parallel to that, if you want to explore a quick and cost-effective resolution of the matter, you might offer proposals on a without prejudice basis. So, for instance, a partial or complete sell-off of unsold stock, discounted or possibly even no compensation, not taking direct action against wholesalers and retailers, and also confidentiality terms. And before sending out any cease and desist letter, do consider potential traps. So in the UK, for example, we have provisions around unjustified threats, where a defendant can effectively turn the tables on you and seek an injunction or damages, especially in borderline or weak cases. Those provisions apply to not only UK registered and unregistered designs, but also EU registered and unregistered designs. There are limited exemptions to those provisions. So if your cease and desist letter is purely aimed at the manufacturer or importer, or if it's purely notifying a defendant about your registered rights, or if you're purely approaching a wholesaler or retailer to identify who the manufacturer or importer is, those can be exempted from the threats provisions. It used to be that us lawyers were also at risk under those provisions, but we are now generally exempt following some recent changes to the legislation. So in borderline or weak cases, one thing to consider to really try and avoid those risks is possibly only referring specifically to certain EU countries, but not the UK, or also just doing your letter by way of a without prejudice letter and not as an open letter. Next is the EU IPO torpedo risk, which Martin will explain a bit later exactly what that means. But a possible way around that is to actually issue court proceedings before sending a letter, and then not necessarily serving the proceedings until you've had the defendant's response to your letter. The other thing to think about, again, which Martin will be touching on later, is the risk of a declaration of non-infringement and the defendant trying some forum shopping to tactically delay the proceedings. And we will now move on to tackling cease and desist letters when you are the recipient.
Hello, again, this is Martin Prohaska from Austria. So there are basically three types of demand letters. First, they come from small designers who don't often have even a design registrations, but are just morally outraged. Second, they come from big luxury brands that own well-known designs. And third, and increasingly, they come from trolls who want to use the registrations to press for royalties. An example is the design of the Tesla semi-truck, where Tesla was recently hit by a US troll in the US. So what's important on that? So first is that you have your defensive materials prepared and check on the risk when you particularly have products out on the market. So in a trial situation, they usually have a particular modus operandi, and searches can be helping in framing your strategy and response. Also important is finding industry partners. If a design trial is targeting you, it is almost sure that other companies are getting the same hit. So search out potential partners to align strategy and possibly share costs. And last but not least, prepare for other trials. Once you have been identified as a target, ensure that you take extra care to prepare for defending yourself from future trials. Now, moving on to scope of protection.
So, defining the scope of protection is important, first of all, when you want to defend your rights, but also when you want to defend yourself against an attack. The design rights, as Tom Carl previously already pointed out, are very useful rights because the design grants its holder an exclusive right of exploitation, so it's a positive right of use, and it also gives the owner the right to prevent third parties from using the design without their consent. And protection extends to all designs which do not create a different overall impression on the informed user. So the scope of protection does not only cover identical designs, but basically also similar designs that give a similar overall impression. So how is this scope of protection determined? First of all, you have to identify the characteristics that make up the nature of the design. You have to consider the design freedom. The higher the design density, the lower the scope of protection of the design will be. And then you have to, in a third step, you have to determine whether the overall impression of the contested design matches the overall impression of the earlier design, and carefully take similarities as well as differences into account. So as you can see, the threshold is that all this must appear to the informed user. And who is this informed user? He is somewhere between the average consumer, that is applicable in trademark matters, who does not need to have any specific knowledge and who, as a rule, makes no direct comparison between the trademarks in conflict, and between the sectorial expert, who is an expert with detailed technical expertise. So, to sum it up, you can say the informed user is not a user of average intention, but a particularly observant one, either because of his personal expertise or his extensive knowledge of the sector in question, and if possible, he will make a direct comparison between the designs at issue. Please pay attention when attacking based on an unregistered design or receiving an attack, because for an unregistered design, the contested use must have resulted from copying the protected designs. So if the holder of the offended design succeeds in proving that he did not imitate the unregistered design, for example, he can prove that he planned this design earlier, protection of the unregistered design fails. Typically, however, the more similar the older and the younger design are, the more likely it is that actually copying took place, and this is what courts typically assume unless proof is given to the contrary. For the scope of protection, it is also important to have a good look at the representation of the design. And as you know, you've got, when filing for a registered design, you have several chances or several opportunities of getting a representation. You can make a graphic or a photographic reproduction of the design. You can make drawings. You can go for a reproduction in black and white and as well in color. And if you go for color marks, for color designs, they will be part of the scope of protection. Make sure that if a drawing is handed in for non-visible parts which simply are necessary to be depicted to get a 3D version, use dotted lines so that visible and invisible aspects can be differentiated. So please be aware, the pictures you are seeing on this slide mostly are bad examples. So for the representation of the design, it is of key importance that the subject matter is clearly defined. So protection is only given for visible features. Please do not file illustration of unnecessary elements. And the design must be reproduced on a natural background. Typically, no protection is given for individual parts of the design. So when you look at this cupboard as well as on the chessboard, you immediately have a couple of questions at hand. First of all, is this bowl of apples part of the design? Or if you look at the chessboard, what exactly shall be protected? Is it one of the figures? Is it the figures in combination with the chessboard? So these designs make it impossible almost to define the scope of protection. On the other hand, when you see these lovely trunkies down there, which Tom has already spoken about earlier, this is an example that the registered design, which is very clear and limited, wasn't enough to give protection against the copying, which used a specific stripe feature. So you may also want to make sure that when you file your designs, that you file for a very simplistic, basic version. But if you've got very typical design elements which vary, that you also ask for protection of the variations so that your scope is sufficiently broad. Now I hand over to the enforcement section.
Thank you, Wiebke. Well, in the event that you have a design right and that you have assessed that a third party uses a design with the same overall impression, you might want to consider enforcing your design right if a cease and desist letter does not lead to the desired result. You can enforce your community design rights only at designated courts in the EU member states that have exclusive jurisdiction for infringement actions, declaration of non-infringement, and invalidity actions. If you want to enforce a national design right, the jurisdiction of the court will be decided by national laws. The big advantage of the harmonized design right legislation in Europe is that you can obtain injunctions against infringers that apply to the entire European Union. A community design right court in the EU is competent to impose such a pan-European injunction if the legal proceedings are initiated in the country where the infringer is domiciled. There are, however, several cases where the infringer is domiciled in a country of the EU where you rather not want to go to court for financial reasons or for the reputation of that court. Another reason you might want to avoid the country where the infringer is domiciled is to have the proceedings in your own country in the EU or in another jurisdiction where most of the damage as a result of the infringement are incurred. In such cases, you can also go to the court in the EU member state where the infringement has been committed or threatened, even though the infringer is not domiciled there. However, in that case, the court addressed is only competent to impose an injunction in that specific country of the EU. And this, of course, limits your possibilities as a rights holder to enforce your community design right in the entire European Union. There is, however, a way you can still create jurisdiction for those courts to impose a pan-European injunction, even though the infringer is not domiciled in that country and only the infringement was committed there. Jurisdiction can be created by including a company or person that is involved in the infringing acts and that is domiciled in the jurisdiction of your preference. And a good example is if a local distributor of infringing products, by summoning not only the foreign supplier and source of the infringing goods, but also the local distributor, the court could be competent to impose a pan-European injunction after all, and against all defendants, including the main infringer domiciled in another EU member state. And in the Nintendo Big Ben case of the European Court of Justice, it was confirmed that a community design court may grant a pan-European injunction where there are multiple defendants based across the European Union, as long as one of the defendants is domiciled in the country of the community design court, and as long as the cases against all defendants are factually and legally the same. In other words, if you have several infringers from different EU member states inside, you can create jurisdiction in the EU member state of your preference. And I'll move on to obtaining ex parte injunctions. As soon as you've decided on which court to address, the question comes up if you can obtain ex parte injunctions. Those are injunctions that are imposed without the infringer being heard. And based on the community design right regulations, the courts are allowed to impose injunctions, orders to seize infringing products, and order to seize materials used in the course of the infringement. How to obtain an ex parte or other pre-judgment measures is, however, dealt with on a national basis and differs in all EU member states. In the Netherlands, obtaining ex parte injunctions in design right cases is only possible in case of very clear infringement and clear indication that the design right is valid. However, since design rights are not researched before registration and only checked on formal requirements, Dutch courts are very hesitant to assume the validity of your design right without the other party being heard and being able to show possible prior art. Therefore, it usually has to be a clear-cut infringement before you will get an ex parte injunction in the Netherlands in design rights cases. Other pre-judgment measures, such as seizure of infringing products or evidence, is easier to obtain in the Netherlands, especially if the measure is not too burdensome on the infringer, for example, if only samples of infringing products are seized or only copies of certain documents are seized by a bailiff. In all cases, you have to show urgent interest in obtaining such pre-judgment measures without the other party being heard. In other words, you would have to convince the court why preliminary injunction proceedings cannot be awaited, even though such proceedings usually only take around 6 to 10 weeks. And one example in which you probably have urgent interest in ex parte measures is in case of an exhibition or fair taking place for a limited period of time, or when products are offered at a discount store, clearly ending on very short notice. In case you are facing a design right infringement claim, or you have the idea that there is a threat that, for example, a competitor will launch infringement proceedings against you, a good delay strategy can be to file an application for invalidity at the EU IPO, the so-called torpedo, which Tom already shortly addressed. And pursuant to Article 91 of the Community Design Right Regulation, a community design court has in principle to stay any infringement proceedings if an invalidity action is already pending at the EU IPO. Therefore, this could seriously delay the possible infringement proceedings against you. And finally, other local measures are also possible, but should be considered on a case-by-case approach and are usually governed by national laws. And then I will hand over to Tom again.
Thank you, Martin. So this is on the topic of what are known as innocent infringers in the UK. So in the UK we have peculiar rules which are really around the type of compensation that a claimant is entitled to in relation to sales, which were made up to the point when the infringer can be said to not have been on notice of the infringement. So this splits into considering whether it's an EU registered community design right or a UK registered design right. In those cases, the infringer may escape an order for damages if it can prove that it wasn't aware and didn't have any reasonable grounds for supposing that the design was registered. But under UK law, an infringer will not be able to claim that it was innocent if the claimant has marked its product with the words registered, or an abbreviation of that word, together with the registration number of the design. And now, recently, since October 2017, in the case of the UK registered design, again, an infringer won't be able to claim innocence if it's marked registered or an abbreviation with the registration number, or another option is marking your product with a website link, which leads to a website giving clear information about the product and its design number, and that has to be accessible free of charge. And importantly, even if in those situations an infringer can claim that it was innocent, the claimant will still be entitled to seek an account of its profits in the alternative. Now, in the case of the EU unregistered community design right, there, again, an infringer might escape damages if it can prove that it wasn't aware and had no reason to believe that the design was protected as an unregistered right. But again, it could still be liable to an account of profits. And then in relation to the UK unregistered design right, there you need to split it between looking at primary infringers, so in this particular case, manufacturers. There, they might escape damages if they weren't aware and had no reason to believe that the design was protected, but again, could be liable to an account of profits in any event. And then in relation to secondary infringers, so other infringers apart from manufacturers, if they didn't know and didn't have any reason to believe that the products that they acquired were infringing, in that case, the only remedy is damages not exceeding a reasonable royalty, and so no account of profits. And we will now move on to costs orders.
So, thank you very much, Tom. Cost orders are a peculiar thing throughout Europe because they are dealt with differently in every member state. So what I'm having a look at is a possibly very peculiar way we're doing it here in Germany. So what do the costs depend on when you had a court case and you want to figure out how much you have to pay to the court and to the other party, or if you want to determine in advance how the financial risks are when starting or initiating legal proceedings? So the costs of a lawsuit in Germany typically consist of the court costs of the proceedings, and of the out-of-court expenses, which are the lawyer's fees and expenses of the two parties. But for assessing the risk, it's particularly important to have a look at what your defendant will want to get if he wins the case. The amount of cost depends on the dispute value, and this typically will be determined by the court. However, the parties usually give an indication what they think is the relevant dispute value because they know the value of their brand. So in design law proceedings, the value in dispute typically ranges between €50,000 for a not particularly well-known design up to €500,000 or even more for very well-known designs. So don't get a shock when you see this slide. It's just an example of how mechanical the whole process is, because the costs of the proceedings and the court costs, they're all determined by statute, and depending on the individual value, you can type it into a calculator, and according to the legal proceedings, you get an information on the amount of money which you will have to pay for each different step. So I give you a short example. So if you are in ordinary jurisdictions, first instant case, and you have an amount in dispute of an estimated €100,000, the court costs, without costs for taking evidence, will be, in the first instance, €3,078. Plus out-of-court expenses for the other parties, if their position prevails, is the opposing lawyer's fees, without tax and other fees. And for the legal representation in proceedings in the court will be €3,757. So The costs for the other party and the court expenses in case you lose the case will be approximately €7,000. So this is an amount of money you can calculate with, and you can make a proper risk assessment of how much the whole thing will be. So I now move on to conclusion and takeaways.
Thank you, Wiebke. So we're now almost at the end of this webinar, and would like to conclude with some takeaways on design right protection in Europe. And after these takeaways, Tom Carl will answer one question that was raised during this webinar. First of all, use NDAs whenever sharing your designs with third parties to avoid disclosure and possible negative impact on registering your design. Using NDAs is also of importance to have your designs be qualified as trade secrets under the new Trade Secrets Directive that has been implemented in several EU member states already. Also think carefully about which and possible multiple versions of your designs to register to achieve maximum protection. Mark and webmark your products to protect against innocent infringers. Ensure you train your designers and create awareness in your company, and make sure to have a good overview of pre-existing designs to avoid conflicts. And lastly, when enforcing your design rights or anticipating possible legal action from your competitors, think about the risks and possibilities of a possible torpedo and decide up front on your enforcement strategy, especially which jurisdictions are most favorable in your case. So before we will end this webinar, we'll now hand over to Tom, who will answer one question we received.
Thank you, Martin. So we've had a question from one of our listeners, if we could just elaborate a little bit more on the fifth option of protecting designs as a registered trademark, which I mentioned we weren't covering in any detail here because it's almost a whole topic of its own. The short answer is yes, it's possible to register your 3D designs as a trademark, but it can be very difficult. So at one extreme, you have the Coke bottle, which would be an example of a protected 3D trademark as a shape. But at another extreme, for instance, we recently had a case in the UK involving the iconic shape of the London taxis, which were registered as trademarks, but were held by the courts to be invalid registrations. So why can it be so difficult? Well, as with any other trademarks, you've got the first hurdle of having to show that the design is inherently distinctive. But you've also got two other hurdles in that shape trademarks will be excluded if they consist essentially of technical features. And the other hurdle is the question of, does the shape add substantial value to the product in question? And whereas you can get around the inherent non-distinctiveness hurdle by showing acquired distinctiveness, which in itself can be a huge hurdle for an EUTM where you're having to show that throughout the EU, acquired distinctiveness isn't a cure anyway when it comes to objections based on technical features or substantial value. So Martin, I think that concludes our presentation.
Okay, thank you, Tom. Well, with that, we indeed come to the end of this Taylor Wessing webinar. We would like to thank you very much for your time and attention. And if you have any questions, please let us know, and we will get back to you as soon as possible.